Muito boa tarde a todos, sejam todos muito bem-vindos ao nosso Table Topic número 10. Bem-vindos também aos demais eventos do nosso 41º Congresso Internacional sobre Propriedade Intelectual da ABPI. Hoje nós teremos um Table Topic bastante interessante, com muitas questões relevantes e que impactam diretamente a forma de gestão dos portfólios, principalmente de patentes, no Brasil e na América Latina. E para isso nós trouxemos aqui debatedores e palestrantes do mais elevado e mais profundo conhecimento a respeito do tema. Eu vou passar agora a apresentação de todos eles em inglês e explicar rapidamente aqui qual vai ser a dinâmica do nosso Table Topic. I will now start introducing our first panelist, Robert Craig Tucker. Robert has been a patent attorney with the Eli Lilly and Company for 21 years. He has been involved in global procurement, portfolio management, international IP enforcement, and IP law advocacy. An active member of various national and international IP law associations, including ABPI, of course, of which he is a member of. Craig has been an advocate for the equitable development of IP law globally. Craig has a Master of Biology, Biophysics, from Purdue University on the 90s and a DJ from Indiana University School of Law, Indianapolis, and 6 years of experience in bioanalytical assay development prior to entering the practice of IP law. I'll pass to our second speaker, our colleague from Mexico, Alejandro Luna. Alejandro Luna is a partner to the firm Olivares, and he joined Olivares in 1996 and became a partner in 2005. Alejandro has been instrumental in IP litigation, regulatory and administrative litigation practices, and co-chair of the Life Science and Pharmaceutical Law and Industry Group, and he also coordinates the litigation department. Mr. Luna has been crucial to the hearts of Mexico intellectual property legal system as one of the few true patent regulatory and administrative litigation experts. Our other panelist today is my partner, Ricardo Nunes. Ricardo is a partner and head of patent practice at Daniel Law, leading both the patent litigation and patent prosecution teams. And Ricardo is licensed in both the state of New York and Brazil. For more than a decade, Ricardo has been advising multinational companies on their most critical matters, including high-stakes complex patent deals and disputes. He has represented clients in a broad array of technology-related fields, including telecom, software, electronics, oil and gas, and mechanics. Ricardo earned his Master of Law degree in Intellectual Property, summa cum laude, from the George Washington University, and a master's degree in regulatory law from Fundação Getúlio Vargas. I myself am a partner to Daniel Law as well. I'm very happy to be here. In a few words, my history goes back to 13 years working in pharmaceutical industry, also in other industries like cosmetics and mechanics. And I'll be happy here to interact with you all during this event. Just to give you an idea on how we will carry on this panel, Ricardo will display a few slides, tapping some issues that are very impacting not only for Brazil, but for other countries in the region as well. And those topics will be, first of all, the compulsory license, for which there is a bill of law recently approved by the Senate last week, and which now follows to presidential sanction. Also, he will be speaking about a lawsuit that revoked the so-called sole paragraph of the Article 40 of the Brazilian intellectual property law, industrial property law, and that article used to grant 10 years as a minimum of a patent term of duration. After Ricardo has explained those points, Alejandro will make comparisons with the situation in Mexico so you guys can have an overview of what's going on in Brazil and Mexico, the two most important countries in the region in terms of market size for most, if not for all industries. And then we will have the privilege of debating the topics then explained with Robert Craig. Robert will be speaking here more as an observer, not representing necessarily the opinion of the company for which he works for, that is Eli Lilly, but as an observer and passionate for IP. So with no further ado, as we have many topics to be discussed, I would kindly ask Ricardo to start the explanation about his topics.
Thank you. Thank you very much, Roberto. Can you hear me well?
Yes.
Can you see my screen?
Yes.
That's amazing. Thank you. Thank you very much for the introduction. And thank you all for watching our panel. As Roberto mentioned, I plan to cover two different topics here, the recent bill that covers compulsory licenses in Brazil and the recent Supreme Court decision limiting the term of protection of thousands of patents in the pharma and medical fields. So I'll start talking about compulsory licenses and this new bill that was recently approved by Congress. When discussing compulsory licenses in Brazil, it seems we need to talk about the past, the present, and even about the future. So let's get started. My idea here is to provide a brief overview, as Alberto mentioned, to make sure that Alejandro and Craig and all our international attendees are in the same page and up to speed when it comes to these recent developments that we plan to discuss. So starting with compulsory licenses, I would like to say that compulsory licenses, they are mainly governed by the patent statute in Brazil, in line with what establishes the TRIPS agreement. There are different circumstances that could lead to the Brazilian authorities granting a compulsory license, such as lack of local working in case of patent misuse or violation of the antitrust rules, for example, amongst others, including in case of national emergency, and also when the government declares that a certain technology that is covered by a patent is of public interest, if such need is not met by the patentee. This is what the patent statute establishes. In the past decades, there was only one occasion when a compulsory license was granted in Brazil, and this was the efavirenz case back in 2007. Efavirenz is a drug for the treatment of HIV that is distributed for free by the government to Brazilian patients under our universal healthcare system. And at the time, the government was not happy with the prices being charged by the patentee, basically arguing that the government of Thailand was purchasing the same drug for a lower price. Compulsory license was always used as a threat by the government, by the Brazilian government, when negotiating these purchase deals. And at these occasions, when the parties were still negotiating, the government decided to suddenly grant a compulsory license. So decided to grant a compulsory license regarding the two patents that were related to this drug. And from my personal perspective, I think this was probably a good example on how compulsory licenses can sometimes be ineffective. It is highly debatable if the Brazilian government was really able to save a reasonable amount of money with that measure, for multiple reasons, including the fact that at that time, And for many years after that, Brazil did not have the capabilities to produce fibrines in Brazil. So for several years, the Brazilian government had to import API from other countries. But I would say that despite this isolated precedent, the fact is that at least until 2021, we could basically say that Brazil had a clear and reasonable rules governing compulsory licenses in Brazil, with guarantee of due process and I would say a legal framework that was basically in compliance with the TRIPS agreement. And then we move forward to our current health crisis, the current days, and COVID-19. I do believe that the current crisis created an opportunity for the anti-patent lobby in several jurisdictions, including Brazil, to act. Perhaps the biggest example was exactly the Supreme Court decision reducing the term of protection of thousands of patents in the country. I'll cover that in a couple of minutes, but I could provide you with other examples, right? We are now seeing, for example, the Brazilian government being pressured to side with India and South Africa in their proposal for an IP waiver at the WTO level. We are now seeing infringers that are being sued using the current health crisis as an argument to try to convince courts not to grant restraining orders or preliminary injunctive relief, even when the accused products are unrelated to COVID-19. And we are also seeing Congress analyzing multiple bills that could potentially limit patent rights in the country. And in this sense, we had a specific bill, as Roberto mentioned, aimed at modifying the rules governing compulsory licenses in the country, being approved by Congress quite recently. As Roberto mentioned, this new bill was related to compulsory licenses that were being granted to deal with national emergency or public interest. This bill was approved by a very large majority with support from politicians from different parties, I would say. And this bill has the potential of creating rules that could generate lots of concerns, I would say. And I can give you a few examples, right? Differently from the current legal framework, so different from the rules that we have in force right now, according to the new bill, the government would publish a long list with patents and pending applications that could be related to dealing with a national emergency or with the declared public interest, after receiving inputs from public institutions, universities, NGOs, lobbying associations. And the government would have not more than 60 days to examine all these patents and pending applications and issue a decision. Hopefully, we would see some kind of due process during these proceedings, but it's hard to tell because the bill is not that clear on that. There is a provision establishing that the government would not grant a compulsory license if the patentee agrees with meeting the necessity at price, volume, and terms deemed adequate. And of course, it is quite unclear what that means. There would be a 1.5% royalty rate, standard royalty rate, no matter what the field of technology, which can be a concern, and this would be applicable until the government establishes a more specific rate. So we may have to do with a standard royalty rate, and someone might ask why 1.5%, and my answer would be I don't know. But it was the same royalty rate that was established for the E5 case back in 2007. So maybe it's a kind of a magical number that we found, more than a decade ago. Also, one point that for me raises major concerns is the fact that in addition to the federal government, Congress would also be able to grant compulsory licenses. So for me, this is a point that raises concerns, even though folks are not talking a lot about these specific points. But perhaps the biggest issue that we were able to identify when analyzing this bill is the fact that the approved bill establishes that the patentee would have an obligation of sharing information, test results, biological material to allow a licensee to reproduce the claimed technology. So basically a forced tech transfer. Otherwise, the patent could be invalidated. Of course, this is a major concern for the research-based industry. I would say this is a concern for the industry in all fields of technology, and possibly a violation of international agreements and the federal constitution. We might have an opportunity to talk more about that. So this is potentially the biggest concern that some stakeholders might have. This bill was approved by Congress and is at this very moment at the president's desk. He could either pass this bill into legislation or veto the bill entirely or only certain provisions. However, even if there is a veto, Congress would still have the power to overcome such veto, and these new rules could potentially become legislation. So this was the first topic I wanted to briefly cover, again, for the benefit of Alejandro and Craig and all the international attendees that are watching us. And the second topic I wanted to cover, as Alberto mentioned, is this recent Supreme Court decision regarding the term of protection of patents in Brazil. Again, for the benefit of our international attendees, I just wanted to mention that the legal provision governing the term of validity of patents in Brazil since 1996 is Section 40 of the patent statute. And Section 40 basically establishes that a patent shall be enforced for 20 years counted from the filing date, but its sole paragraph used to say that the term of validity cannot be inferior to 10 years counted from the date of grant. And this was a very important legal provision because due to the backlog problem we used to face, and I'm extremely happy to say that Brazil was finally able to deal with the backlog problem, and the Brazilian PTO in the past 3, maybe 4 years, the PTO has been doing a great job at reducing the backlog problem. But I would say that this legal provision was quite relevant because in the past, the PTO was taking, in average, more than a decade to examine most applications. And this was particularly true when it comes to certain areas of technology like telecom or pharma, for example. So this was a very important legal provision. And we had this constitutional challenge that was filed many, many years ago, back in 2016. And this lawsuit, this constitutional lawsuit, was pending. The case was dormant for several years until recent times when the case was randomly assigned to a different reporting justice because the previous one became the chief justice. But also because of COVID-19 and the current health crisis, which again provided the perfect window of opportunity for the anti-patent lobby. So the case started to move much faster this year. Basically, by the March and April, the case moved forward, and the reporting justice decided to partially grant a request for preliminary injunctive relief, basically to stay the effects of the challenged provision when it comes to pharmaceutical and medical applications, that is, without affecting patents that have already granted in Brazil. In addition to partially granting injunctive relief, the reporting justice also decided to make his opinion on the merits public in advance. So he published his opinion on the merits. And so we basically learned that he would try to convince the court to invalidate the challenged provision, the 10 years from grant provision, and that he would try to convince the court that as a general rule, patents that have already granted should not be affected, with the exception of patents in the pharma and medical fields, and patents that were already being challenged before a court of law with these based on these particular arguments. So this happened earlier this year. And then, as I mentioned, in May, the Supreme Court was able to deliberate about these case. And by a large majority, the court decided to basically agree with what the reporting justice was saying, basically invalidating the 10 years from grant provision. That is, from now on, the applications that are being examined and granted by the PTO will not benefit from this provision, no matter if they are pending for more than a decade or not. And in addition to that, the Supreme Court decided to agree with the reporting justice, also by a large majority, that as a general rule, this decision should not affect patents that have already granted, with the exception of patents in the pharma and medical fields. So this decision was probably the most relevant court decision in the past decades in Brazil. It invalidated an important legal provision, but also immediately impacted the important industries like the pharmaceutical and the medical industries in Brazil. As I mentioned, this decision basically affected more than 6,000 patents. This is just a quick visual representation of all these patents that were enforced in Brazil by May that were affected by the Supreme Court decision. Of course, you can't see that, but the tiny horizontal green lines are the remaining term of protection of these patents. So this was the situation back in May 2021. If we took into consideration all the remaining term of protection for all these patents that were affected, we're talking about more than 15 million days of patent protection, remaining patent protection. And then with the Supreme Court decision, basically companies saw their term of protection being dramatically reduced. In total, we can say that more than 1/3 of the remaining term of protection was gone suddenly by these Supreme Court decisions. So, of course, this decision has had a huge impact to companies doing business in Brazil. We believe this decision might change the way companies do business and manage their IP rights in the country. So, for example, we might see secondary patents becoming more important in Brazil now that compound patents expired or had their term of protection reduced. We might see, for example, more companies using not patent law but the Food and Drug Law to try to enforce their rights in Brazil. We might see an even bigger effort at the PTO's side to combat and deal with the backlog problem. So we should expect to see the Brazilian PTO continuing to do that kind of work. And we can also expect to see more applicants taking advantage of the multiple fast-track options that were created by the Brazilian PTO in the past years to allow applicants to expedite examination of their patent rights so that they do not get pending for more than a decade in a way that they will not be harmed by this Supreme Court decision. So with this kind of overview on these two topics, I would like to again thank you all for watching us. And Roberto, if you can keep moving forward, that would be great. I'll stop sharing my screen.
Sure, Ricardo. Thanks very much for this quick but important overview on what's going on in these two fronts. But before I mention something about the Article 229C that turns the Anvisa review of formal patents mandatory, I'd like to skip to Alejandro. And summarizing, Alejandro, as we could see, Brazil is clearly heading in two directions. One is in the first topic that Ricardo explained about compulsory license and making the rules broader. And I don't know if you agree, but in some way more vague and indefinite in the criteria to select the patents that would be subject to that. And very concerning, I would say, also covering situations of national emergency, not only in Brazil, but in other countries as well. So we have these enlargement, so to speak, of the rules that could accommodate a compulsory license. And secondly, as Ricardo explained it, we have the Supreme Court deciding to revoke an article of law that was in force for around or more than 25 years, granting the minimum of 10 years for any and all patent. Can you please share your thoughts and say if Mexico is going in the same direction, opposite direction, or what are your thoughts about these two specific issues?
Thank you, Roberto. Thank you, Ricardo and Craig, and to the ABPI for this invitation. Thank you very much. And thank you to allow me to be close to the country of my wife and my three kids. Regarding, obviously in Mexico, there are now various hot topics regarding with IP, because we have since November the 5th, 2020, we have a new IP law. So there are many topics of interest right now in our country, but I'm going to limit my talk today to these two topics that are already being discussed in this panel in connection with the compulsory licenses and the life term of patents. Regarding the first topic of compulsory licenses, I will start by mentioning that no compulsory licenses in Mexico have been granted, especially the compulsory license for causes of emergency. In our IP law, since the beginning of the last century, we have this possibility of compulsory licenses for two reasons: for non-exploitation of the invention. The general rule was 3 years after granting of the patent. If there was no exploitation within the country and no reasonable excuse for that exploitation, it was possible to anyone to request a compulsory license based on non-exploitation. And actually, the law established a 1 year of the title holder to cure that eventual non-use or no exploitation of the invention within the country. But I believe that the most interesting is in the compulsory license based on emergency causes. In that regard, I will comment an anecdote in this regard, because when the law, the new law was discussed in Mexico, we already were in the pandemic, or during the pandemic. The discussions of the new IP law took place within the pandemic. Actually, most of our interventions as attorneys devoted to IP and the Mexican Association of IP Attorneys. Most of the discussions with the Senate and the Congress were online because we are already on quarantine. However, there were many changes to the IP law, mainly because the obligations of Mexico with international treaties, such as the USMCA with the US and Canada, and the CPTPP with 10 more countries. And notwithstanding the provisions regarding compulsory license for causes of emergency, there are many areas of opportunity of improvement. There was no amendment, there was no review, and there was no change in the provisions of compulsory licenses, which is really odd, but because we were already in the pandemic, and there was no any change there in order to improve what we have already in our that we had in our previous IP law and remain exactly the same in the new IP law. So obviously that's a criticism of the work of our Congress, because they didn't even review that chapter. But in short, I would say which are the main conditions for an eventual compulsory licenses based on cause of emergency. The causes should be that very limited when there is some hinder or overprice in the supply or distribution of the patented product. So that is the condition for compulsory licenses. And even in the 2010, when we had the emergency or the sanitary emergency of the influenza H1N1, these conditions were never met. So that's why we haven't ever the compulsory licenses. But the compulsory licenses are not automatic in our system. It's necessary that the Health Council must issue a declaration of emergency in the official gazette. In this pandemic, we have already done, it has been already published. And obviously it's necessary the application of the compulsory licenses, but it's through the payment of royalties. The law says that should be paid under the payment of royalties. It doesn't mention how the royalties is going to be paid. It only mentions that it should be decided by the Ministry of Economy. And there is a right of hearing or to be heard by the title holder of the patent. More or less, in brief, what I will comment regarding the chapter or the provisions of compulsory licenses in Mexico is that they follow the standards or the minimum standards of TRIPS. I mean, this should be temporary during the period of the emergency. There should be a right of hearing of the title holder under the payment of royalties, and to these causes to defeat the emergency only. So now in this regard, in Mexico, there has not been any petition, even with the COVID-19 cause of emergency. There had not been any petition of compulsory license formally. There was some petition with one single and isolated senator in the Senate, encouraging the Health Council to review the possibility of grant compulsory licenses to defeat the pandemic of COVID-19 for vaccines, for eventual, pharmaceutical products, and for any medical device that would help to defeat the pandemic. But there was a very isolated petition by one senator, and there has not been any formal, process that it is established in the IP law to continue with the possibility of grant compulsory licenses in Mexico. So now regarding the life term of patents, what I heard, what happened in Brazil, in Mexico, it is happening the opposite. Well, now we have in our IP law, we have the possibility to compensate the life term of patents when there is some delay in the granting, in the process of granting the patent. There are some rules to establish that that compensation. I mean that it should be no longer than 5 years. The compensation. There is some exceptions of the delays by the Mexican Patent Office. I mean, should be directed by the Mexican Patent Office. If there is some delay caused by the patent applicant, they should not be taken in consideration as a delay. And that this is very recent. It has been enacted in November last year, so it has been not tested yet. We trust that it's going to be, interpreted and applied within the next 4 years for patents that has been applied after November the 5th. But in addition to that possibility of our current law to compensate the life term of patents, any type of patent, not only for pharmaceutical patents, any type of patent, as Ricardo said, we consider in Mexico that limit some law or regulation to pharmaceutical patents will be discriminatory. So, and because we have that principle of law in our Constitution and in several secondary laws and in our case law. In addition to that new law, that we have this possibility of compensation of life term of the patents because of the delay in the granting, there was a decision 1.5 years ago by the Mexican Supreme Court. It was a divided decision. It's now public. It's called the Bayer case. In that Bayer case, Bayer argued that, and it was a patent, obviously granted pre the new IP law. Bayer argued that INPI, the Mexican Patent Office, took more than 5 years to grant the patent. So according to an internal decree of the Mexican Patent Office, that was already a delay. So because that delay, they argue that according to NAFTA, the previous USMCA, not the current USMCA, that NAFTA establishes that the patent term should not be less than 20 years from the application or 17 years from granting. So Bayer argued we have more benefits with the option in NAFTA of 17 years after granting. And because the delay of more than 5 years, the granting of that patent, we requested the amendment or the compensation of that patent to expire 17 years from granting. And the Supreme Court, in this divided decision, 3-2, in one of the bench of the Supreme Court, they rule on behalf of Bayer. And they order INPI to amend or to compensate the lifetime of that patent. In my personal opinion, I completely agree with the rationale of the Supreme Court that if there was a delay of more than 5 years, the patent should be compensated. I completely agree with that. I do not fully agree with the remedy that was provided by the Supreme Court in granting the lifetime of 17 years after granting of the patent. In my opinion, the court should order INPI to compensate the life term with some equity rules to compensate the life term of the patent, or applying the rules of compensation of lifetime of patent that at that point in time they were not in force, but they were already under discussion of the Mexican Congress, which is the rule is to compensate the delay 1 day for 2 days of the delay. So for me, that should have been the remedy to apply some equity rule for the compensation, or to apply the rules that were already under discussion, but not to order to restore the patent, because it was already a restoration, to restore the patent for 17 years after granting. But what it is clear is that Mexico is following a different path to what it is happening in Brazil, in both the compensations for patents that were granted after November the 5th with the new law, where there's some clear rules for compensations on the delays, and the courts are already compensating the lifetime of patents for delays, even without the new law in force. So obviously, I will be open to any comment or question in this regard.
Fantastic, Alejandro. So I will now turn to Robert and ask Robert, clearly those changes, mainly the ones that are occurring now in Brazil, are gaining traction because of the pandemic. And I would like to hear your view on that. I mean, do you think that imposing compulsory license rules that are broader than the other ones and facilitating or forcing, and sometimes, the tech transfer, the supply of biological samples, as it is the case for the Brazilian Bill of Law approved, is this the right way to more efficiently fight against the pandemic?
Yeah, I would suggest that it's the opposite thing. It's definitely will have a chilling effect on access of new medicines to Brazil across the board, not just in times of pandemic, but certainly then. If you stop and think, if all of the innovators who have invested years to create an ongoing critical mass of scientists, regulatory people, business people, put in place to be able to identify, research, develop, and then launch products that are going to improve healthcare. That's a lot of infrastructure that has to be there and funded over a long period of time. If you don't get an adequate return on the investment that required to get that medicine there, that machinery will disappear. You cannot support it. And as I'd stated in another presentation, is it's government that's going to pay for that and keep it maintained and working to its best efficiency. I think most people would suggest that the odds of getting payback on it are so low that that's not what people want their governments spending money on. How do we know this? Because they don't want the government spending money on the healthcare to begin with. They're always, complaining about the prices that the healthcare is paying. They want to go lower, 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 not pay what you have to get the innovation. That's properly in the private sector, in the innovator sector, to bring on new ones. Then it becomes, within time, at the right time, the place for generics then to take over and bring prices down after you've already compensated. So you can keep the discovery machinery going, and then you bring in improvements for everybody over time. That's the way it's actually written up in your Constitution, though it was kind of turned around backwards in the Supreme Court decision to say the opposite almost. But to require compulsory licenses, or to set up such an easy way to not only bust the patent, as they say, but then to also force tech transfers for things that go beyond the disclosure of the patent. This is going very far beyond patent law. This is a government taking of everything that somebody somewhere else already developed. They invested hard money to develop, to bring to people, and now you say you're not going to compensate them. Or you'll compensate them at 1.5% of the generics price, which is token. That's ridiculous. I'd like to wonder what's the profit margin on generic. Are they taking 1.5% or less profit on producing their things? I don't know. We'll come back to that in a moment on a comment. But also the time element, to compensate that innovator, that minuscule token. Maybe you might give a more reasonable royalty, which would be based on the actual economic value, which the law says you need to do. What is that economic value? Well, it's still up here with the global value of that medicine. Even if you have to argue and fight for 10 years to get that and get compensated for that, the machinery was not supplied the benefit of that invention until 10 years later. Excuse me, my kids are grown. I've already passed the time to have to pay for their college, their healthcare, their housing, their transportation. That's too long of a period of time, and you can't have an adequate lifestyle if you've invested years of to put yourself in a position to be able to contribute to medical advancement. So you have to be able to have a real-time compensation of the innovator, not some litigation down the road 10, 20 years, and then, oh, well, now you finally get paid off, if you ever do. So compulsory licensing is definitely the wrong direction to do. TRIPS was, fought to bring IP to the pharmaceutical industry as one of the key advances of it, so that all fields had IP patentability for all countries signing on to TRIPS. They put in the provision that if there's an actual emergency where the patentee cannot provide the need, then you can grant the compulsory licensing. You're not going to be bound to it. But there was always two different viewpoints that were being fought there, to either grant the pharmaceutical IP or not. And under what conditions can you safeguard the legitimate needs of society when the patentee can't provide for the emergency need? One idea is exactly what it says. If the patentee can't or won't give you the invention, provide it for you in an economically normal way, which means economic value paid up front on the time, or taken on a loan, or taken on, we go into debt for many things. Why not that in a pandemic? Why take it away from them in order to give it to somebody else who has to come up to speed to provide the need? That's false. In my opinion, that's false. So that was one view. The second view is that there ethically should not be any IP on pharmaceuticals. It should be run by the state. It should be funded by the people in general. nobody should be making profit on medicine. Doctors, ambulance drivers, the truck driver of the medicines, they should not be making any profit on pharmaceuticals. It should be given as a right to people. That's a different viewpoint, and they always fight to reduce the viability of IP along that way. So you have these two different viewpoints fighting, and whether or not they will come up with intermediate things that sound good, but at the bottom line, TRIPS wording says if the patentee cannot meet the need. So that brings me to my second point. It all seems to really boil down to price. Nobody trusts the innovator to give it at a price that we can afford, particularly if you're not one of the top countries. How do you pay for this? How do you get to it? And compulsory licensing keeps being brought up as a way to do it. Bust the patent, then you can go ahead and take the IP and get it at whatever bargain basement price a generic house somewhere can provide it for. But that's not the same thing, and that's not what the TRIPS says. So in my opinion, compulsory licensing is only going to chill any time that there's an emergency. Am I going to spend $1 billion of my money to get it done? Am I even going to put in $500 million while the government puts up $500 million, which is more along the model that's actually there? And under some circumstances, not all circumstances, in this COVID, there was a lot of public money that was put up, but not in here. What proponents of compulsory licensing would suggest that it was all already paid. No, that's not at all the case. So there's the opinions on compulsory licensing, whether it's going to help or hurt, right direction or wrong direction. I would like to make two other statements about the compulsory licensing bill. Roberto, you had made mention of one of them led into forced tech transfer. This would have an even greater chilling effect because it goes beyond what the patent law requires. What the patent law requires is that when you make an invention that's new and non-obvious and has industrial applicability, you get an exclusive right to market that for a period of time. And so for that, you write a description that tells one of ordinary skill in the art how to make and use the invention claimed. If my invention is a new compound, I've invented it on this day, and it gives certain activities that would suggest, yes, it hits the right biological targets. It might work as a drug. At that point, you know a new product and you need to patent it at that time. You disclose how to make that compound. You describe how to generally use it to treat that disease. But then it's a long line of development after that to actually make it a dosage form that you can take reliably. You don't know at that point if you're going to have to come up with new formulations. You don't know if you're going to have to do particular kinds of dosings to overcome something that wasn't part of the original disclosure, and it wasn't part of the original invention. Your invention was a compound that could be used. And so now you have to also, wonder about toxicology. You can use it, it'll treat the disease, therefore it satisfies the description. But, oh, gee, you're going to have this side effect. That's not good. So you don't have a product yet. You can't take that to the market. You're going to have to overcome that new technical problem to be solved to be able to get a product. And so it's a long timeline. And if you're dependent only on that compound case way back at the beginning and you can't get to the market till much later, you need something more to be able to compensate the investment. Those new discoveries were not part of the patent. It was not part of the deal cut by presenting the patent, teaching how to make and use it. That now this compulsory licensing law is requiring you to give up. you're going to give up much more. All of those subsequent innovations, subsequent trade secrets that you've figured out how to effectively, efficiently, best optimized routes, formulations, you're going to have to give all of that up. That's far beyond. That's just flat out government taking. That's misappropriation. That's government sponsored misappropriation of trade secrets. How's that going to pan out in any industry, let alone a pharmaceutical industry? So yes, it will have a tremendous chilling effect if that goes into effect and if that's enforced. And it goes beyond why should your patent be busted, be invalidated for not disclosing those other trade secrets and things. I think that we need to go back to the TRIPS Doha view, take price out of that equation of whether to give a compulsory license or not, see if the patentee will supply the need and work out with them to do it, rather than using it as a aggressive negotiation tool to bring down the price to commodity levels, i.e. don't give you any value for your invention that will keep your machinery running and invest in the future of our people while providing good medicine now as well. Those are my comments on that.
Fantastic. Thanks very much, Robert. And on the top of it, I would say that even if all those issues that you have brought up were sorted out in terms of pricing, etc., we still have lots of difficulties in getting proper manufacturing facilities all over the world to manufacture vaccines and medications in an amount sufficient to supply all the needs. And we also have some difficulties in finding out, extracting the materials that are necessary to produce certain vaccines. I read in an article last month that for one specific vaccine, I won't cite the name here, but for one ingredient of one vaccine, it's necessary to collect 17 different sources of material just to produce it. So this gives an idea on how complex certain medications can be to be manufactured. Thanks very much.
I think I'd like to add on to that if I could, because the point
please.
of that is that if you have too many people competing, trying to supply that need, I think the point you're making is that you don't have enough source for all of those disconnected, uncoordinated efforts. You need to be able to focus on the few that have the capability to meet the need if you're honest about wanting to just meet that emergency need. And that's best done by licensing, coordination, and agreement, which honors IP so that everybody's comfortable making those deals. And that's exactly what we have seen with the innovative pharmaceutical industry as a whole through this pandemic. In unprecedented manners, it's been the IP and being able to rely on the agreements that IP will sustain you, that you know you can afford to make that investment. You can afford, and you know who you're dealing with, so that it'll actually be successful in getting as much product made, as much product distributed to the patients that need them as fast as you can. It played out. IP works. Don't compulsory license it, because that takes away all of that.
Okay, fantastic. Thanks very much. I would like to remind our audience that you can send your questions and comments through our chat. We'll be happy to debate about your questions at the end of this session. Ricardo, I recall that we discussed it in the beginning that you will say something about the plan of the Brazilian PTO to fight against the backlog. Do you think that the way that the plan is being carried out and to the way it's being heading to the outcome, will it be enough to compensate for the revocation of the sole paragraph of Article 40?
Well, Alberto, thank you for this question. I certainly do not think that it will be enough to compensate for that Supreme Court decision that, in my opinion, can be detrimental to the patent system. But I think that at least when it comes to new applications for example, the ones that are being filed now in Brazil, we won't miss this legal provision that much because, yes, the Brazilian PTO is making a huge effort in tackling the backlog problem. I started practicing patent law about 15 years ago, and for many years, the backlog problem was only getting worse year after year. Different governments, different leadership, until about maybe 4 years ago, back in 2016, I think it was when the Brazilian PTO started to be more successful at this task by using clever ways of dealing with the backlog problem, by taking advantage of examination that is taking place abroad by foreign patent offices. And the PTO was indeed able to reduce the backlog, and this is still, a work in progress. So I truly believe that in about 3, maybe 4 years, we will be in a much better position, much better situation than we are today. And yes, in a certain way, this legal provision that was invalidated, right, Section 40, sole paragraph, was only applicable when the PTO would take more than a decade to examine a certain application, which used to happen very often, which is not happening very often now, and which hopefully will happen very rarely in the future. And I think these efforts towards tackling the backlog, together with these new tools that are being made available by the PTO to allow applicants to expedite examination. For example, now, if there is someone infringing or reproducing at least one of your pending claims, you can ask for expedited examination. Now you can ask for fast-track examination if your application is related to the treatment of certain diseases like, HIV, cancer, neglected diseases, rare diseases. So now we have many fast-track options that can be used, including what I believe is one of the best tools to allow companies to expedite examination, which is the multiple patent prosecution highway agreements that were signed by the PTO between the Brazilian PTO and several foreign patent offices. In the past, these PPH programs were fairly limited because they were limited to certain areas of technology like oil and gas or IT, but they were expanded more than a year ago. So now you can use the PPH program no matter the area of technology. And this is not only a great way to expedite examination, but also to increase your chances of obtaining patent protection. If you take a look at the statistics, the average allowance rate goes up from about 68% to about 90% if you use the PPH program. It is a cost-effective measure because you don't have to deal with many office actions. So this is a great thing for the future, right? To prevent the Supreme Court decision from having an even bigger impact down the road. But this has nothing to do with the major impact that the Supreme Court decision will cause right now when it comes to these over 6,000 patents that had their term of protection reduced by the Supreme Court. So we might need to find a different way to fix that issue. So, for example, Alejandro mentioned that in Mexico, you have a new rules governing patent term adjustment. So this is something that we might need to think about in Congress at the PTO level. Courts might need to think about that as well. So we might still need to find a solution to fix this immediate harm that was caused by the Supreme Court decision, in my opinion.
Thank you very much. Alejandro, about the term that the Mexican Patent Office is taking to examine a patent, can you give us an idea on how long it takes from filing to the publication of a granted patent?
Yeah, I would say that in Mexico, fortunately, during the last 12 years, I would say, the backlog was in the granting of patents in Mexico was considerably diminished. I mean, now the average for getting a patent in Mexico from the application date on the national phase to the granting, on average is around 4 years. 4 years, that is the average. And that we have some tools now to shorten that period of time. We have PPH with more than 12 offices, patent offices around the world. And now we have like a cooperation, internal cooperation agreement between the Mexican Patent Office and the USPTO in order to save the patent examination or to facilitate the patent examination of equivalent patents filed in the US and Mexico. So with that, we consider that this patent adjustment, actually when the negotiations of the treaties were in place, and this one of the main issues under discussion or on the table of the negotiations of USMCA and the CPTPP. To be honest with you, this issue of patent adjustment was not the priority for the innovative companies in Mexico, because the timing to get a patent in Mexico, I mean, it fulfills more or less the international standards. So we were more focusing on other issues, data pack exclusivity and patentability of new uses and others issues of more relevance. Because the timing of getting a patent in Mexico was not really a problem. Obviously, there were some exceptions. There were some exceptions, and that's why we had the buyer case and other concerns in the granting of certain patents. But in the timing of getting some patents. But now that we have the new IP law, we have the clear rules. We have the clear rules that if INPI complies with the terms to granting a patent, it is fine. But if they delay for some reason, there is the possibility of these adjustments, and that is very positive, because avoids the uncertainty of litigation. With the buyer case, in which personally I agree with the rationale, but I don't agree with the solution, because the solution in my case, they went beyond what it was applicable to that particular case.
Fantastic, thank you. I think that to take benefit of the momentum, I will skip the order a little bit here, and I'll share a question with Ricardo that is coming from the audience, Ricardo, and it has all to do with what we are just discussing here. I'll translate a question here. The argument by the Supreme Court when judging about the sole paragraph of Article 40 was the compensation given by Article 44, by which the owner of the patent is ensured the right to obtain indemnification for the undue exploitation of the patent, including for the exploitation between the publication and the granting of the patent. So do you think that this Article 44 is something really effective and justifies the rationale brought up by the Supreme Court? And Alejandro, to you, there's the question if there is a similar mechanism in Brazil. I'll let Ricardo explain, and then I'll pose the question again to you, okay?
Sure, thank you, Roberto. So Alejandro, basically, this legal provision was establishing that after you're able to obtain your patent in Brazil, you could, in theory, sue someone for patent infringement, counting from the date the application was published in the official gazette. So the period of time for when the application was still pending at the PTO, in theory, the patent statute establishes that you should be able to obtain compensation for that. And yes, Roberto, I was not able to read that question, but this was an issue that was discussed at the Supreme Court. And of course, Supreme Court justices, they are not expert in patent litigation, right? They can't be. They need to be experts in other stuff, other very important stuff. But the fact is that the fundamental right provided by a patent is the capacity of preventing others from reproducing the claimed technology. This is what a patent means to do. Yes, if you're not able to do that, then the second best scenario would be to obtain compensation. This is particularly hard in a country like Brazil, that you might take, more than 10 years until courts are able to issue a final decision on the merits. And I'm saying 10 years because I'm being nice. It could take more than 15 years, for example. And then you still need to fight for a few more years until you're able to calculate the damages awards. And then a few more years until you're able to collect the damages. So this Section 44, it's very interesting, but it's somehow a bit of science fiction. You won't find many examples of companies that were able to sue infringers for past infringement that took place, let's say, 10 years ago or 15 years ago, right? Very, very hard to prove, to obtain evidence about stuff that happened 15 or 10 years ago, right? Companies don't even have financial documents about, financial records about products that were sold 15 or 12 or 10 years ago. So in practice, it never happened. So I do not believe that this is enough to compensate patentees for the delay in obtaining, for the delay the PTO takes to examine and grant these patents. And Section 44 was always in place. It's just not very practical. So with that, I was about to say that, Craig, that I think Craig perhaps might have something to add, and then later we can hear from Alejandro if you're.
I was actually hoping that you would also opine on irreparable harm, because this supposes that you can be compensated even with time. Maybe you'll fund your retirement instead of your kids' education. But can you speak about how Article 44 deals with irreparable harm of being able to actually do your business with your invention now, which is your livelihood?
Well,
Yeah.
Please go ahead, Alejandro.
Oh, sorry. I just wanted to comment that we have this very similar rule in Mexico, in which you can request damages or compensation in a retroactive manner to the date of publication of the patent. It has not been used because, as you mentioned, very similar to what is happening in Brazil, in Mexico, patent litigation, and to be able to claim damages a long path, because it's necessary first, or at least with the previous law, it was necessary first to have this final decision of patent infringement, all this administrative process with eventual 4 stages of litigation to have a final decision to claim infringement, and then we're able to claim damages before a civil court with other three stages of litigation to claim damages in a retroactive manner to the publication date. So we had that rule. We have it in our current law. It was not an issue discussed in the Bayer case, but we have that rule. It has changed a little bit because now the new IP law opens the possibility to claim damages directly before civil court. So in theory, it will be the path to claim damages, it will be shorter with the new IP law rather than the old IP law, but still we have this rule of damages claim it in a retroactive manner to the application date.
And I was just going to add that this kind of argument, pretends that a patentee makes money by suing other people. That's not how it works, right? A patentee is in the business of performing R&D, manufacturing and selling, high-tech products. That's how a patentee makes money, not by suing everybody. So this kind of argument, to be sincere, it sounds to me similar to saying that it's okay if someone punches you in the face, because you can always sue him or her and obtain damages in an amount that fully compensates you. For me, that doesn't make much sense, and we should be thinking about developing systemic solutions to some of our problems, and not incentivizing even more litigation. We already have a lot of litigation in Brazil. Courts are already incapable of dealing with all these lawsuits. Another line of argument was saying that, well, a patentee should not worry, because you could always sue the patent office and try to obtain compensation for delay. Again, sounds a bit like science fiction, because no court will issue a significant damages award against the PTO, ordering the PTO to pay dozens of millions of dollars for a company because of the delay caused by due to the backlog problem. So I think we need to start thinking about systemic solutions instead of saying that if you're if you think you are facing some harm, you sue everybody.
I completely agree, and that is the reason that in the Supreme Court decision of the Bayer case, and under the discussions of the new IP law for the patent term adjustment or compensation, the main issue was how to provide this effective exclusivity, or this privilege to be effective enough to preserve the exclusivity, not to try to make compensations and to get compensations to third parties, just to be effective in time for the exclusivity that it is granted by the Mexican state.
Okay, thank you. Have any further comments, Robert, or can we skip to another question?
Please proceed.
Okay. Another question that is coming here, and by the way, this question is authored by the same author of the previous one, Antonio Carlos Souza de Abrantes. And the other question from Antonio is, if the patent needs a trade secret to be implemented, and no one is capable of implementing the patent without knowing that trade secret, of course, how do you analyze? I think the best person is you, Ricardo, to answer that. How do you analyze that situation in face of the sufficient disclosure?
Well, first of all, for the benefit of Craig and Alejandro, it's really nice to know that this question is coming from Abrantes. He's one of the most knowledgeable patent scholars in Brazil. He's with the Brazilian PTO. He has a famous blog as well. So really glad to receive this question. I would say that, well, the patent statute already has an answer for that, right? The patent statute establishes that the applicant needs to contain enough information to make sure that a person having ordinary skill in the art will be capable of reproducing the claimed invention, right? Of course, and this is established by Section 24 of the patent statute. I must say, for me, it's one of the most interesting issues in patent law. Unfortunately, it's not discussed enough in Brazil, in my opinion, at least not as folks do it in Europe or in the US or in Japan. So I think the patent statute already has an answer to this question. Of course, the details are way more complex, but one thing that we need to bear in mind is that one thing is to allow a person having ordinary skill in the arts to reproduce the claimed invention. And I think Craig talked a little bit about that. One thing is the claimed invention, a certain compound, for example, right? Yes, we need to make sure that the patent has enough information to allow a person having ordinary skill in the arts to reproduce the compound. But one other thing is, the final product that is sold in a pharmacy or distributed by the government under our universal healthcare system, right? There is still a way between, the claimed invention and what you buy or what you take as a final product. And I think part of that knowledge can be also protected as a trade secret. The patent statute does not force the applicant, for example, to disclose information for mass manufacturing, for example. So there is still a lot of room for the protection of trade secrets if this is something that the innovator is willing to do. Sometimes you have different options. You might seek patent protection or trade secrets, treat your information as trade secrets. Sometimes you don't have these two options, but I think the patent statute already deals with that.
Fantastic. A classic question, classic answer. Thanks for the question and thanks for the answer.
I'd like to add that it's
important.
Yeah, it's important. Two aspects. The first is directly to that, and sufficient disclosure, an enabling disclosure. It's been long tradition that if you teach how to make the compound, so that's the chemistry part that's disclosed, you've described the compound and not a little something and its function and then claim all the world that might fit the function. That's too broad. No, you got to say what it is, describe what it is, how to make that. And then that is useful for treating a disease. Yes, it might treat lab rats in the disease, but that's a long way yet and might involve lots of other steps along the way to optimize it and to know how to get it to the product. It's very analogous to a lot of other fields where you might have a patent on how to make nanotubes. And that is then the core piece of your technology that you then develop to create a really awesome new high-tech device in your hand or something that could do something. And what the compulsory licensing is asking you to do is say, teach us how to do this when your patent is on how to make that first nanotube. You protected all the rest of this with trade secrets. People can go ahead and if you bust the patent on the nanotube, make the nanotube, but that's not very useful. What you want is that final device kind of a thing, but that's a whole new thing. It's the same with pharmaceuticals. The second part that comes into that is subsequent innovation. Patents on dosing regimens, patents on crystal forms that actually have a functional use, have a difference in the way that it handles and treats in the manufacturing process, in the shelf life, in how it's absorbed by the body, things like that. And so subsequent innovation adds new value to the thing because it solved the technical thing. The patentability standard is exactly the same. It's got to be new, inventive, and be industrial applicable. And so that new invention is a advancement worthy of its 20 years of patent coverage as well. When the patent expired for the compound, Well, fine, you can now make and use the compound according to how it was disclosed back then. Now you found a new crystal form of it. You can't use that crystal form. If you can still get the drug on the crystal form over here, great. You're free to market that. If you have to use this crystal form in order to get the kind of biological uptake that is useful, avoid side effects, faster onset, some useful piece that makes that crystal form inventive for which you got the patent, that should be honored as well. So subsequent innovation, it's just like the improvement of the phone, the next generation of phone. You can't get the old phone and practice the old phone if it's covered by the new invention. You can do that old phone, but you can't do the new phone. What they're asking for is don't give them the patent or honor the patent on the new form, and that's not right.
Perfect. Well said, Craig. I recall many times when I was in Sanofi discussing these issues with my peers, and once I heard an example that was saying that when you develop a chemical compound, you're not absolutely sure if this is a medication, a pesticide, something to put into an atomic bomb or into your car to make it run. So you need a lot of extra efforts in research to make sure it becomes a medical product and it is approved by regulatory rules. Okay, we are right on time to finish our panel. I would just like to ask Robert if you want to say some wrap-up words before we finish the panel.
Thank you so much for inviting me. I thoroughly enjoyed discussing this panel. The questions were great. It would have been great to have more robust discussion with all of the members of the audience. I do look forward in time as a member of ABPI to have those kinds of discussions with you all. It helps us all to improve when we have a holistic view and we argue for a balanced IP thing that works for industry and society as a whole.
Thank you. Alejandro?
Oh, thank you. Thank you very much for the invitation and for the opportunity of sharing what is happening to Mexico. And I believe that these exercises are very positive for countries of the region in order to change or to comment about these common issues of concern. So thank you very much.
Thank you. Ricardo, what about yourself?
I just want to thank you again, Roberto, for the invitation, and thanks ABPI for putting together a great event, and thank you all for watching us today.
Okay, I want to thank you, Robert, Alejandro, and Ricardo for the brilliant explanations and very interesting discussion we just had. I had mentioned in the beginning that I would say a few words about the revocation of Article 229C, but taken by the time, it's not going to be possible to do it here. So if you're interested in getting more details, you can drop an email to me or to Ricardo. We'll be happy to share that. Thank you, ABPI. Thank you for organizing this panel, and I hope you all enjoyed the rest of the Congress. Bye-bye. Thank you.
Thank you. Bye-bye.